Hi, everybody. This is Samantha from the law offices of Samantha Wolfe, and I'm here doing our new installment of our virtual seminars. We did take the summer off, so June, July, and August. We did do our centerpieces with the nieces series. Those are up on our YouTube channel as well as on our website, but we wanted to get back into doing our monthly virtual seminars. So this is our first one to kind of start off the school year in September. So thank you all for being here. We're happy that you came. Our office is located at 20 East 6th Street, Suite 206 in Waynesboro, Pennsylvania. And you can reach us at 717-655-2676. And I wanted to remind everybody who might be listening to this now or might be watching it on our YouTube channel that we always do offer consultation. So if it's something where after you hear the material presented, if you have follow-up questions, I'm always happy to answer them. In our next couple of seminars, we're going to do something a little bit different. So we're going to do more of examples where we're actually using some fact patterns that we've come up with, that we've seen a lot with our clients, and then offer kind of our proposed plan for those clients, just so you can kind of see different situations that might be helpful to you. And this month, we're actually focusing on special needs planning. And we're focusing on that for two reasons. So the first is that October is Special Needs Month. And so we wanted to make sure that we had this information out for folks to be able to use, whether it be for their loved ones or for themselves. And secondly, I think special needs planning was on the forefront of my mind. I think I've talked about it before, but I do have a niece who has some special needs, and I was able to spend some time with her in August. And so it was just a topic that we hadn't gone over in a while. So we thought maybe we would revisit it. And I had Amy kind of pull together some hypotheticals that we'll go over. So that being said, let us get started. We're going to share our screen and go through our PowerPoint presentation. All right, this is our office. I know that we have moved office suites. So even though we are still Suite 206, our address hasn't changed. We are now up on the second floor. And so this is a picture of the outside of our building. And then we always like to start off our seminars with our mission statement. So I wanted to take a minute and have our mission statement on screen just so we can go over that. So here at our office, we always feel like it's important for all of the staff to kind of know what we're working towards as well as our clients. So we really like to collaborate with the accountant and the financial advisor to create the best team. We like to advocate for you and your family during times of crisis. We like to reinforce your estate plan with asset protection strategies. And lastly, we like to ensure efficient administration upon your death. And so we strive to do that across all of our areas of law. So today we're talking about special needs trust, protecting our loved ones today, tomorrow, and forever. And like I said, we will be posting this on our YouTube channel under our virtual seminars. We have a playlist that includes all of our monthly virtual seminars. So this one will be included after today. So what's important to know is that a special needs trust is a very important legal document. So whenever I meet with a client who has a loved one who does have special needs, we always start with talking about special needs trust. Now know that a special needs trust is not the only mechanism in which you can plan for an individual who does have special needs. Pennsylvania does now allow the ABLE accounts. So we do talk about that in one of our other presentations where we kind of go over more of the broad spectrum of special needs options and the planning that can go along with that. Today, like I said, I wanted to focus on some examples with some trust because I do feel like trust can be a little bit confusing and a little bit overwhelming. So my goal today was to give you very concrete examples and show you how in those examples we use special needs trust in order to be able to accomplish the client's goals. So a special needs trust is a specialized type of trust. And what it allows is if you set it up properly and you fund it properly, the individual who is receiving benefits, it could be that they're on SSI or SSDI. It allows them to still be able to qualify for those benefits while also receiving whatever inheritance that you wanted to make sure to go to them. So the language that's special in Pennsylvania is it has to supplement but not supplant whatever benefits that primary beneficiary may be eligible to receive. So, for example, if the benefit is designed for shelter or food, then the distributions from the trust, we want to make sure they don't fall into either of those categories. You can make a distribution, the trustee can make a distribution for whatever else, as long as it's not supplanting what that government benefit was for. Things that you might want to consider for a special needs trust is you always want to think, what's your goal? And you'll always want to kind of do a cost benefit analysis. So supplementals and special needs trusts, we use those words a little bit interchangeably. There is a slight differentiation between those two types of trusts, but usually we're using them for the same individual. So you want to think through the cost benefit analysis. Trust can be a little bit more expensive than utilizing an ABLE account, but it's usually something that you want to consider because it can protect the assets more and you can protect a larger amount than you can with the ABLE account. Second thing you want to make sure to consider is the trustee. So the trustee is the individual who's going to be making distributions out to the beneficiary. And special needs and supplemental needs trusts, I think, are even more important to weigh who the trustee is, because normally you do need someone who's familiar with that beneficiary's needs, concerns, what they're dealing with on an everyday basis. That's not to say that you can't name a bank as the trustee of a supplemental or a special needs trust. It usually means, though, that you want to have, if you're going to have a corporate institution, you want to have also a personal individual. It could be whoever the caregiver is. I had one client who had a longstanding relationship with the nurse that was providing care for their child. And so they wanted that nurse to be part of a team that worked together as the trustee. So it was like a collective unit. There were 3 individuals that were named. One of them was a corporate institution, and all of them had to work together in order to make distributions to that beneficiary. Third thing to remember is the beneficiary cannot have direct access, meaning that the beneficiary typically is not going to be allowed to be the trustee because they're also the beneficiary. So you can't have them making distributions out to themselves. It has to go through the trustee who makes distributions. And then lastly, you want to consider the funding of the trust. So you want to consider what government benefits they might be on. And then you also want to consider the quality of life for that individual. So I always think of special needs and supplemental needs trust as something that really enhances somebody's life, because a lot of times clients will come in and say, well, I don't want to leave my inheritance, or I don't want to leave a share to my child who may have special needs because they're on a government benefit. And so what a trust allows them to do is to receive their share of the inheritance and also still qualify for that benefit. So that's why I really like supplemental and special needs trusts. I feel like they're a great tool to make sure that we're really advocating and doing what's best for our clients. Okay, that being said, let's talk about the 3 types. So there's a third party. That's my favorite. If we had to rank them as, which ones are my favorite, the third party supplemental or special needs trusts are my favorite. The reason is because this type of trust is established by usually a parent or a family member for the benefit of that individual that has special needs. And usually these type of trusts are funded through maybe a will, or we're going to see an example of another time that we use to fund it during life with certain assets. But the important part about a third party supplemental needs trust is that when the beneficiary passes away, those funds do not go back to the state. They actually would go to whoever you name as the contingent beneficiary. So for example, for my sister and her husband who have Audrey, that's my niece who has special needs, if they would create a trust for Audrey's benefit and something would happen to Audrey and there's money left in that trust, that money is not going to go back to the state to, I guess, reimburse them in a way for some of the benefits that were paid. Instead, what can happen is my sister and her husband could create the trust that says if something happens to Audrey, then the money left in the trust can go maybe to Audrey's brother or maybe to another beneficiary that my sister and her husband have selected. So it doesn't go back to the state. That's why third party special needs trusts are so powerful in the planning side of things, because you can really make sure that your client's funds are going where they want it to help the beneficiaries that they want to help. Know that a third party special needs trust are using funds other than the beneficiary. So again, if the beneficiary would be in a car accident and would be awarded funds as a result of that accident, you're not going to use a third party special needs trust to own that settlement fund, those settlement funds. It's going to have to be a first party supplemental needs trust or special needs trust, which is our second category. So a first party, this is where it gets a little confusing. It's all about whose money or who's entitled to the money. So for example, if mom and dad want to set up a trust for the benefit of the child, they create a third party special needs trust. They fund it with their money. It's not the beneficiary's money. The beneficiary is not automatically entitled to it just because the trust is set up. A first party supplemental needs trust, again, a parent, a grandparent, or a family member creates it, but typically the funds for a first party special needs trust are the beneficiary. So that's where, in one of our examples we'll get to, there was a car accident and this child was severely injured. And as a result of that, had some pretty extensive issues that they're dealing with on a daily basis and a lot of special needs that they have to address. Because that money from the settlement, it's entitled to pay to that beneficiary, it has to be a first party special needs trust. A first party special needs trust does have to have what we call payback provision, which means that if that beneficiary passes away, those funds do have to pay back to the state. So you can't set up a first party special needs trust and think that those funds are going to be able to be directed somewhere other than back to the state. So that's one big distinction I wanted to make sure everybody knew. So no, it's not who creates it, because in both the third party and the first party, it's going to be a parent or a loved one. It's really about whose funds are they? Are they mom and dad's? Are they the beneficiaries? That's what determines what type of trust. A third party special needs trust does not have to be approved by the caseworker for the beneficiary. A first party does have to be approved. So if we do have somebody who has gotten like maybe a personal injury settlement or an accident settlement, and we want to put it in a first party special needs trust, we do have to have it approved by the caseworker of the Social Security Administration if that's the benefit that's paying. Lastly, the third kind of special needs trust is a pooled trust. Again, it can be established in this case by the beneficiary, a family member, or a guardian. Usually it's administered by a nonprofit. And the goal here is that it's pooling funds. So for example, if it's not a large amount that's coming from a settlement and it doesn't make sense to use a standalone first party special needs trust, it may be something where you use a pooled fund where other individuals who are experiencing the same situation and trying to still qualify for their benefits are using the trust in that way. So it's like a pooled trust where all of the funds are coming together. It allows the beneficiary some bigger investment opportunities. So that's really what a pooled trust is. In our office, we do predominantly third-party special needs trusts, because when we're doing estate planning, it's usually mom and dad or the grandparents who want to leave an inheritance to that individual with special needs. And so we're able to use a third party, which, like I said, it's always my favorite because it allows us to provide for the beneficiary, but not have to pay back the state. So when in doubt, you always want to make sure that you're asking about the possibility of using that third party special needs trust. Okay, so that was our fun intro where I just spout off a lot of information for you guys about the type of trusts. Now comes the fun part, or I hope maybe kind of the learning part for everybody. So what we want to do over the next couple of slides is we've selected 4 case studies, and it is based on some of the situations that we've experienced here at the office. And what we've done is we've kind of accumulated or compiled the proposed assets. And again, we're using made up families here. It's based on certain situations, but none of these facts are specific to one client. So the first case study we're going to do is the Blue family. So the Blue family came into my office, husband and wife. In this case, we're going to affectionately call them Keith and I guess Amy is Ima. Yeah. Keith and Ima. I wanted to say Uma, but that's not right. It's Ima. So Keith and Ima Blue come into our office, and they have a daughter who has some special needs. So they're in their mid 50s. They have a long-standing marriage. They've been married for 27 years. They have two daughters. One daughter is now married and has kids of their own. And then the second daughter, who we're going to call Summer in this example, has some special needs. So let's talk a little bit about what assets are in their estate. And this is important because we always like to have at least a rough estimate of assets. What are they? Are they real estate? Are they retirement? Are they investment funds? Are they an annuity? So that's why we find it so helpful and so important to be collaborating with financial advisors, because we know the legal side of it and your financial advisor is going to know all the investing strategies. So we like to usually have the financial advisor involved in the appointment just so everybody can be on the same page. In this example, Keith and Ima have a primary residence of about $300,000. It's currently owned between husband and wife jointly, which is pretty typical for a husband and wife who've been married a long-standing marriage, 27 years. The reason that a lot of husbands and wives choose to do that, two reasons. So the first is if husband passes away, the property automatically goes to wife. Nothing has to be done. If husband dies, a new deed doesn't have to be done. Title automatically invests in the wife. So it's great for estate administration purposes to try to streamline that and make it easier when the first spouse dies. Second reason that they might do it is it does give a certain level of creditor protection. So in this case, if husband would be sued and wife is not being sued, it's just Keith who has the cause of action against him. In that case, the primary residence, again, primary residence, they're always exempt to a certain extent depending on the creditor. But also know that even if it wasn't, if it was another piece of property, if husband and wife were owning it as what we call tenants by the entireties, then if Keith is being sued, that property is not subject to that claim because wife is considered 100% owner of that. So you get an added benefit as a husband and wife if you own it as tenants by the entirety. So that's why we see it in probably 99% of cases where we have a husband and wife. They also have a bank account jointly owned, an Edward Jones investment account that's jointly owned. They have an Edward Jones investment account with the husband. And then they have an Edward Jones account that's a retirement for wife and one for husband. And this is one that we actually did get a referral directly from the Edward Jones advisor for this client because they knew they had kind of talked to us about the special needs situation. They kind of knew that there was something that could be done. So this client came to us through a referral through their financial advisor. So the main concerns they had was that daughter Summer was an individual with special needs. And so they had two things. So the first was what happens to Summer when they pass away. And then secondly, if they need long-term care, would those funds be exhausted? And what does that mean for Summer? Because again, Summer may live a really long time. And so they want to be able to provide care no matter how long she lives. So it was really important to them that they be able to support her. She is unable to work. So again, the primary financial support she gets from her parents. So they didn't want all the funds to be used for long-term care costs because then that leaves nothing left over for Summer. So we're going to move on and show kind of what we did in this example. So keeping those two goals in mind. So remember, want to protect Summer, and then secondly, we want to protect Keith and Ima from long-term care costs. So in Pennsylvania, there are assets that are exempt. Jess, let's go back to the other slide real quick and talk about that before we actually get to the plan. So know that the primary residence is an exempt asset, which means that if Keith goes into the nursing home can't force Ima to sell the primary residence. But in this case, if Keith goes into a nursing home and he passes away while he's in a nursing home and he happens to be the surviving spouse, it then is going to allow the Department of Human Services to put a Medicaid recovery lien on the house. And that's a big deal because in this case, that's where Summer is going to live. So Summer does have a longstanding nurse that's with her every day. And so the thought would be is that if something happens to Keith and Ima, Summer's going to live in that home with her nurse. That's where she's comfortable. She's used to it. They can financially do that. So that's the goal that they want. So even though the primary residence is exempt for their long-term care costs, they still are going to want to protect it because they don't want the Department of Human Services to come back at their death and potentially take that house to satisfy any Medicaid that was paid during Keith and Ima's life, because then it would leave Summer without a primary residence. Second thing to know is that when we're talking about retirement, if Keith goes into the nursing home, his retirement is available, but Ima's is not available for his care. So we're looking at what's available. Primary residence is technically not available. And then in the situation where Keith would go into the nursing home, Ima's retirement is not available. Then they do allow Ima, in this case, to keep a vehicle, usually pick the one of highest value if both individuals have a vehicle. And then she would be allowed to keep about $130,000. That's what we call the community spouse resource allowance, meaning that Pennsylvania says we're going to go ahead and give that to the spouse regardless of what other assets they have. So when we're looking at this, even though the Edward Jones investment account is just in husband's name, whether husband or wife need care, that Edward Jones investment account will be available for long-term care. So we always want to think about that $130,000 because that's really not a lot. So when we're looking at these assets, it would really financially compromise not only Ima, but also it leaves Summer in an unfortunate situation as far as her care and being able to receive care. Okay, Jess, now let's go to the next one. So in this case, what we did is we're using a variety of trusts. So let's start at the left box. This is, just know that Keith and Ima both have a separate will. We don't ever do joint wills, but in order so that we could fit all of the trusts on the plan, we did include just one box. Both of their wills are reciprocal wills, which just means that they look the same. It's just reversing the names, husband or wife's name, depending on whose will we're talking about. So the first thing that we did is we recommended that they update their last will and testament. So know that the will is not going to govern anything that transfers via beneficiary designation. So if the IRA, if anybody would ever have life insurance or that's jointly, any asset that's jointly owned, that's not going to pass through the will until the second spouse dies. But we just want to make sure we're covering every possible asset. So we always update the will. And you're going to see here what we did is we had everything paying to each other. And then upon the second spouse's death, it pays to Summer's supplemental needs trust. And then the other half goes to the daughter who is married and has kids. But we wanted Summer's share to definitely go into the supplemental needs trust because she is receiving government benefits. In this situation, she was on SSI. So we want to make sure that we are properly allocating that to her supplemental needs trust. Summer is over the age of 18 in this example, so also know that too. The next box over is Summer's supplemental needs trust. And this is a revocable trust. That means that Keith and Ima at any point can revoke it, can change any aspect of it. But we do have it created now because if they'd ever want to be transferring assets to Summer now, so for example, if they would want to transfer $50,000, we would want it to go into this trust. So we created what we call a standalone third-party special needs trust. And we did that so that they can fund it while they're living, as well as have their will paid to it and update the beneficiary designations for the retirement accounts so that the contingent beneficiary is Summer's supplemental needs trust. Because again, we have to think through the beneficiary designations, because if we go to all the trouble and expense to set up this supplemental needs trust and it pays, the beneficiary designation pays outright to Summer, then we haven't really helped at all. So we wanted to have a standalone third-party supplemental needs trust. The next box over is a trust that we would use for Keith and Ima's primary residence. Like we talked about, it's an exempt asset for them if they would ever need care, but we're concerned about when they both pass away, making sure that no creditors, the biggest one we think of is the Department of Human Services, because if Keith or Ima ever needed long-term care during their life, the Department of Human Services would be able to come back against the estate. If the house passes through the will, then it's subject to the Department of Human Services lien. Any other creditors too, they're going to be able to come back on what goes through the last will and testament. So what we did here is we created a standalone irrevocable grantor trust that does protect the assets against Medicaid or against long-term care costs in this case, as long as the house has been owned in the trust for 5 years. So think of it this way. If Keith goes into the nursing home and Ima decides she wants to sell the primary residence, as soon as you sell it, it takes an exempt asset and immediately makes all of those sale proceeds available for long-term care. So what this trust does, this primary residence trust, is it kills two birds with one stone. It allows us to protect the house during their life against their long-term care costs. And then secondly, it also prevents that Medicaid recovery lien. So when they both pass away, we can make sure that it goes to Summers Supplemental or Special Needs Trust, which is what this trust is designed to do. The next one over is an income-only protector trust. So we have the income-only, and then the one on the far right is what we call, actually they're both income-only. So we just have two listed there. And now that I'm thinking about it, you can look at the bottom. This is where we do a plan. So it shows us what is funded. So in this case, we had a business that was receiving rental income. And so we wanted to put it into the one trust, the income only trust number one. And then we wanted it to own some other real estate. We wanted it to be designated as an IRA beneficiary for the spouse. So let me explain that concept. So like we talked about, Ima's IRA is not available for Keith's long-term care costs. However, if Ima dies and it pays to Keith as the primary beneficiary, then we've taken something that wasn't initially available for Keith's long-term care. And when Ima dies, we've made all of that retirement available all at one time for Keith. So instead, if we name the primary beneficiary the income only number two trust, what it does is it allows us to say, if at the time of Ima's death, if Keith is in a nursing home, it's going to pay into the trust and it's not going to be an available resource to pay for his care. We're also then going to update it so that the contingent beneficiary, we might do something where it's Summers Supplemental Needs Trust, 50% contingent beneficiary, and where their other daughter, who in this example, I think her name is Grace, she'd be the other 50% beneficiary. So we might do that. We might also do what we call a tertiary beneficiary. So we might name the income trust number two as the primary. We may name the spouse as the contingent, and then we may name 50% to Summers Supplemental Needs Trust and 50% to Grace. The reason we do that is because if when the one spouse dies, if the surviving spouse is not in a nursing home, they are the trustee of the trust and they can disclaim, which means it doesn't pay into the trust, it pays to the contingent beneficiary. So it could pay out to the spouse, and if they're not in a nursing home, they may want those funds. It also allows us, if they wanted to get it down to Summer quicker, they could do another disclaimer and get it down to her. So this is just an example of, there are actually 4 different trusts that we used in this plan, but we did use, and I'll just mention it again so everybody's on the same page, it is a standalone third-party supplemental needs trust. This means that Summer can keep her SSI benefits and can still receive the 50% share from the estate at her parents' death. We would want to transfer the house into the trust. We'd want to transfer any other assets that Ima and Keith want to protect against long-term care costs into the trust. And then we want to make sure that we're updating those beneficiary designations so that it's going to the trust as the primary, Keith and Ima's trust, and then we want to make sure it's going to Summer Supplemental Needs Trust. Remember, because it's a third party, we get to say in the trust document that if Summer passes away, anything left in the trust can pay to Grace. Okay, so case number 2, we're going to use the Green family as an example. And again, facts, we just took situations that we have in our office and changed them a little bit just for our examples here. So let's meet the Green family. Let's see what their situation is like. So in the Green situation, we have Dr. Green. He's a widowed father of 3 children, and he has one son who's on SSI and has a medical card. And in this case, this situation actually came to us from an attorney referral because Dr. Green had already done his will and had done his estate planning. And the other attorney recognized that, you know what, with son being on SSI and having a medical card, there might be some additional protection that could happen. So how can Dr. Green leave assets to his son? So let's talk about what assets he has. So he has a primary residence. He has an IRA. Those are the big assets. Okay, so Dr. Green wants the primary residence to go to his son, and we'll call him John in this example. And then also, John's going to get a 1/3 share of that IRA, and we want to make sure that doesn't pay to John outright. We want to make sure that pays into trust for John. So in this situation, we still have a large quantity of assets that we're dealing with, but it's not as many as in the Blue family, where there was real estate, there was investment, there was retirement. In this case, we're dealing with just a primary residence and retirement. We're also not worried in this case. Dr. Green is not worried about long-term care costs. So we're not going to be doing any special trust to protect assets against his long-term care. In this situation, what we're doing is we're protecting John's 1/3 inheritance plus the house that will go to him. We want to protect that so that he can still receive his government benefits, his SSI, and also receive his inheritance. This is really important because SSI is used to cover housing and food. And so the fact that the primary residence is going to John in trust is really important, because otherwise, if the deed just went to John, it would be problematic for him. So this is a huge example of how a supplemental needs trust could really help protect John and allow him the most benefits that we can get. All right, so let's look at the plan that we did for John. So what we did here is we did a supplemental needs trust for him. Again, it's a standalone third-party supplemental needs trust. We called it the John D. Green Supplemental Needs Trust. It's a grantor trust and it's fully revocable. The reason that we did this is, remember, Dr. Green wants to transfer the primary residence into this trust. So we want to make sure that Dr. Green is the trustee. If he wants to be, he can change it. For tax purposes, it's his. So, and then we want to set it up so that when it goes to the next generation, Dr. Green has those trustees set up. Remember, there are 2 other siblings in this case. So here, in this case, Dr. Green deeded the property, the primary residence, into the trust while he was living. So the deed actually says the John D. Green Supplemental Needs Trust. The benefit there is, first of all, even though Dr. Green didn't mention this as one of his goals, because son is on SSI, and we're going to talk about this at length in one of our other hypotheticals, but because son is on SSI, if Dr. Green transfers assets into this standalone third-party supplemental needs trust in a situation where the beneficiary is already qualified for SSI or SSDI, he would immediately qualify for Medicaid if he needed to do that. That's important because normally when you make a transfer, for example, in the Blue family, the example we just looked at, there's going to be a 5-year look back period to protect the assets from their long-term care costs. That's why it was so important that they were in their mid-50s, because most likely they'll make it through the 5-year period. In this case, Dr. Green doesn't have to worry about a 5-year look back period, because if he transfers it into this third-party supplemental needs trust, immediately he'd be able to qualify for Medicaid if he wanted to do that. Now, one reason he might not want to do that is because he does have quite a bit in retirement. And if he transfers it to this supplemental needs trust, it would trigger all the deferred taxation that he has on that IRA. But in this case, we're able to transfer the primary residence. Then what we did is we reached out to the financial advisor, and this advisor was actually through the bank. And we reached out to the advisor and we asked him to update the beneficiary designations so that John's 1/3 share pays into the John D. Green Supplemental Needs Trust. So the house is in the trust, and as well as his 1/3 of the IRA. The other thing is that Dr. Green didn't mention this as a concern, but in this example where he has an IRA that has designated beneficiaries and the only other asset he has was the primary residence, by transferring it into the supplemental needs trust, we've been able to avoid probate for Dr. Green. And that's because all of the assets either have a beneficiary designation or are owned in trust. The only exception in this case, which we didn't include on the slide, was a bank account. You know, he had his everyday checking account, but it actually had less than $10,000 in it in this situation, so it didn't need to be probated. So we not only were able to protect John Green's inheritance, so that he could still receive his SSI benefit, but we were also able to make it so that Dr. Green's estate didn't have to go through the probate process. So even though that wasn't his goal, we were still able to accomplish that. All right, let's go to our next slide. So case number 3 is the Wolfe family. So again, we're taking some facts that we've seen in recent months and we're going to tailor it to this presentation to let us know. All right, so in this case, grandfather, his name is Jasper, he has a self-funded special needs trust for his granddaughter, Winter. Winter was severely injured in an auto accident and it left her unable to speak or to walk. So let me break this down a little bit for you. So we wanted to include this example because this is the first time we're seeing a first party supplemental needs trust. The reason it has to be a first party is, again, grandfather Jasper still has to create it. So it doesn't matter who's creating it. What matters is that these funds were as a result of an accident that Winter was in. So she's entitled to these funds. Okay, it's a payout as a result of the injury settlement. So in this case, Jasper created the first party supplemental needs trust, and then the settlement that was earned because of the accident pays into that. So in this case, we don't do personal injury or settlement, medical settlement, but we had an attorney who did do that. And they recognized that because of Winter's medical conditions, that she was probably going to be able to qualify for SSI or SSDI. And so perhaps we needed to have it pay into a first party supplemental needs trust. So he reached out to us and we were able to do that first party supplemental needs trust. The trust has $300,000 in it. And we were able to accomplish his concern, which is making sure that Winter could still qualify for SSI, because otherwise this $300,000 would jeopardize any benefits. SSI has a pretty strict asset requirement. And so if Winter had had assets above 2,000, she wouldn't have been able to qualify. So the 300,000 that was received as a result of the settlement, we needed to pay into trust. So Jess, let's go ahead and advance the slide there. So this one is different. You're going to see that it says irrevocable in parentheses right after the name. We called it the Winter A. Wolfe self-funded supplemental needs trust. It was an irrevocable trust. So a couple of things to know about this. So first of all, it is not a revocable trust. It is irrevocable. It has to be irrevocable. Remember, we have to send this to Winter's caseworker to get approval so that they know, yes, these settlement funds are paying into the trust and the trust complies with what they need on the SSI side. So it does have to be irrevocable. The second thing you're going to notice is that it is not a grantor trust. So grantor is a term that we use for income tax purposes to say who has to pay the income tax on the assets owned in the trust. The assets owned in this trust are going to have to be reported on a Form 1041. A 1041 is an income tax return that's filed on behalf of the trust. So let's say this $300,000 that's invested, let's say it generates $3,000 worth of income in a year. What's going to have to happen is Jasper, who's the grandfather and who's the trustee, he's going to file an income tax return on behalf of the trust, which is a Form 1041. He's going to report that $3,000 worth of income. And then depending on whether he pays it out, and in this case he did because Winter had so many things that had to be paid out for her care, he paid that out. And as a result, then it was K1'd out to the beneficiary. If it had stayed in the trust, then that's when the accountant would have to be concerned about some income tax implications, what tax rate, all of that. So again, that's why we really love to have the financial advisor and the accountant as part of the process, because in this case, we needed to make sure the accountant knew that we needed to get an EIN for this trust, an employer identification number, because we have to file an annual tax return for the trust. And we needed to make sure the accountant understood that this was an irrevocable non-grantor trust. So there might be some tax implications so that this accountant could advise annually what should be paying out of the trust. The other thing to remember about a first party trust is that when Winter passes away, anything that's left over from these funds is going to go back to the state. So this won't be able to go to anyone else at her death. So that's the major downside of a first party supplemental needs trust. All right, let's do our final case. So we're going to call this family the Star family. So this one is a little bit of, again, taking a couple of concepts and putting them together to see what we can come up with. So in this case, father, whose name is Sonny, he fell and needs long-term care. And Sonny has two sons. One is Chase. Chase is about 32, and he receives actually SSDI benefits. And I'll tell you why that makes a difference here in a second. So in this case, I just want to give you the background because I feel like it's always important, whether you're a financial advisor, whether you're an accountant, or whether you're a client, to be able to recognize situations when maybe you need some help. So in this case that we took some of these facts from, the one son, not Chase, the other son, we'll just call him Charlie. Charlie, he actually reached out because he had consulted with another attorney, and that attorney had told Charlie that there's nothing that could be done to protect assets, that because dad needed long-term care, all of the assets would need to be spent down to pay for dad's care. This was a big issue when Charlie reached out to me because if it has to be used for dad's care and Chase is only 32, how is Chase going to be able to live after dad passes away? And so Charlie didn't contact me in this case because he wanted to get dad qualified for Medicaid. That was not his intent when he reached out to me. He was calling because he wanted to make sure, can I do something to protect Chase so that these funds are there to be able to pay through his life expectancy? So in this case, dad had a primary residence that was worth about $500,000. He had a shop, he had a business that was worth about $250,000. He had a townhouse that was worth about $75,000. He had some life insurance that had a cash value of about $35,000, and then he had a retirement of about $150,000. So a couple of things to know is, remember, the primary residence is exempt, but if dad's going to be in a long-term care facility and not going to be able to come home, and in this case, he was not going to be able to come home, he's going to pass away while he's in the facility, which means there will be a Medicaid recovery lien that will come back on that house. Chase lives at that house. So that's a big deal. And Charlie, the other son, really wanted Chase to be able to stay there. The location was good. It was near other family members. It was near his workplace because he did have a job. And so it was really important that we be able to protect this house. As far as the shop and the townhouse went, it wasn't so much that we wanted to protect those specific assets. But what Charlie wanted to do was he wanted to be able to sell those assets and use the cash, invest it so that it could be used for Chase long term. Because he has such a long life expectancy at age 32, those funds were going to be really important to be able to provide for his care. The life insurance I want to mention because it is available for dad's care because the cash value is above $1,500. So we think of life insurance typically as not until you pass away and then it goes to your beneficiaries. But in this case, the life insurance would have been available to pay for dad's long-term care. And then lastly, his retirement is going to be available to pay for dad's care as well. So the concerns we have was Chase's ability to receive government benefits. We also, I shouldn't have called him Charlie. I guess we have a name for him, Weston. So Charlie/Weston, we want him to have the ability to assist Chase with financial responsibilities after dad passes away. And we're concerned about dad's long-term care costs. So we're combining two of these hypotheticals. This is a combination of the Blue family, the first hypothetical, as well as the second hypothetical, which was the Green family. I'm looking at Jess just to make sure I'm getting all the names right. So we're combining them in this hypothetical. So if dad needs care right away, what we're able to do is set up a standalone third party supplemental needs trust, which is what we did. We have Chase's supplemental needs trust. We're able to have the brother Weston / Charlie, whatever name you want to go with, be the trustee, and then the beneficiary is Chase. Because it's a third-party supplemental needs trust, there's no payback provision, and which means that if Chase dies, those funds can go back to Weston / Charlie or go somewhere else. This is important because Dad's will did have everything going equally between his two sons. But Charlie recognized that if he doesn't do something, all those funds are going to be at risk to pay for Dad's care. And so he made the selfless decision to create this trust and transfer 100% of Dad's assets into this trust. Because it's a third-party supplemental needs trust, Chase is the only beneficiary. And by law, he can be the sole beneficiary, meaning that Charlie cannot be a beneficiary of this trust while Chase is living. So basically, in this case, Charlie was able to give up 50% of the inheritance so that it would be there for his brother's care. That being said, we wanted to use a third-party one because if Chase passes away, we wanted anything left to either go to Charlie or to go to Charlie's kids, so that way he's able to get a little bit something back if there would be anything left over in Chase's trust. Jess, let's go back just a second. I want to look at the assets again because we're going to transfer primary residence. We're going to do a deed transferring ownership of the primary residence, the shop, and the townhouse. They're all going to go immediately into the trust. We're also going to transfer ownership of the life insurance immediately into the trust. By doing that, we have protected the primary residence, the shop, the townhouse, and the life insurance without a 5-year look-back period. Because Chase was on SSI benefits, we could dump those immediately into the trust, and there's no look-back period. Normally, we'd have a 5-year period in which those assets would be available, but because Chase is on SSI, we're able to clear those assets, make sure they're protected. Lastly, I had asked Charlie, well, what do you want to do about the retirement? Because we can transfer it into the supplemental needs trust all at once, but then we're going to have to pay tax on it all at once. And so this is where we reached out to the accountant and we asked the accountant to run the numbers. So tax-wise, if we take the hit all in year one and go ahead and transfer that, what tax does that look like when you kind of look at what the tax deductions were through the year for that individual versus what tax are they going to pay? And in this case, Charlie will
Can't hear, Sam.
Hi, everybody. I'm back. We wanted to make it really exciting in this presentation. I apologize. I'm not sure what happened. Sometimes our internet cuts in and out, and so I'm not sure if I lost internet where I am. I have no idea, but I'm happy to be back with you guys. So Jeff is telling me that it cut off right when I was saying about the taxability. So let me just refresh here. So we met with the accountant just to go over what tax bracket was Dad in, how many deductions did he have in that year? And did it make sense for us to liquidate that retirement, which in this case we did do. We liquidated it entirely. We took the tax hit and we transferred it into that third-party supplemental needs trust for Chase. So all the assets went into this trust. Again, knowing that Charlie or Weston in this visual would be the trustee. He's going to make investment decisions. We put it in the trust. He's going to sell that shop and that townhouse and be able to use those funds for Chase's long-term care. So in this case, what happened is the timing was Dad had his accident and his fall at the beginning of the month. And we were able to get Dad immediately qualified for benefits with no look back period. So when Charlie had initially reached out to the other attorney, they were saying that he would have had to spend everything down on his assets, plus the house would have been available. And what we were able to do was protect everything. And so I think it's really important whether you need a supplemental needs trust, you might not be somebody who needs one, but you might know somebody, or you might be a financial advisor or an accountant who knows somebody who needs these services. And so I think it's really important because this can really make or break it for a family. And in this case, Chase now has the funds to be able to be set up for his life expectancy. Okay, the last thing I wanted to talk about, because I know how much fun those hypotheticals are to go through. So let's talk about the trust distribution. If I could say the most often thing I get asked about when we're setting up a supplemental or special needs trust, we get the most calls about, it causes the most confusion, we have the most appointments about, is once we have the trust created, what can a trustee make distributions for? So we created a list and we give this to our clients so that they know. So 1 through 10, and I'm going to go over these, the trustee cannot make a distribution from the trust for any of these things, because if they do, it will reduce the SSI benefit that that individual is on. Now, I want to make sure to say that in the last example, remember, Chase was not on SSI. In all of our other examples, the beneficiary was on SSI. Chase, in that example, was on SSDI. So when we're talking about what the trustee can make distributions for, SSDI is not on this slide. So that being said, that Charlie could make a distribution for anything that SSDI was not designed to cover, and SSDI is not assigned to food or housing. So when we're talking about reducing SSI benefits, in the last example, if the trustee had made a distribution for any of these things, Chase's SSDI benefits would not have been affected. Okay, so you have to figure out what benefit, SSI, SSDI. SSI is always going to be stricter. Okay, so the trustee cannot distribute for food, to pay a mortgage payment, for real property taxes, rent, heating fuel, gas, electricity, water, sewer, or garbage removal. So those all fall under food and housing. So if the beneficiary is on SSI benefits, then I would advise the trustee not to make a distribution, because otherwise it will reduce those SSI benefits. The next slide that we have here is talking about what distributions are permissible. So we always like to say what you can't do, and then we want to follow up with what you can do. So the trustee can make a distribution for medical equipment, for computers, technology, that type of thing, for vacation and the cost of a chaperone to accompany that individual, for school tuition and books, for health insurance premiums, for any hobby activities, as well as any equipment for those hobby activities, the purchase and maintenance of a vehicle, because if you're on SSI, you are allowed to have one vehicle. So you can make a distribution for that one vehicle. For any household items, so if they want a new toaster, new blender, those things can be distributed out. For a security system, and for certain home improvements. So, you want to redecorate or something, you can do that. And as well as the cell phone. So all of those items a trustee can make a distribution for. Then we wanted to add a couple of things that we can still, before we get to the next one, we can still make distribution for cable bills, cleaning and hygiene supplies, clothing, pet and pet care, professional fees, income taxes, a gift card, as long as it's for a store where you're not able to purchase food, credit card, although the credit card bill has to be in the name of the trust, because you can't have charges for food and shelter on there. So regardless, and this was an issue we had with actually the Green family, they were trying to get a credit card and the credit card company wouldn't issue it in the name of the trust. And you just have to shop around to different credit card companies. There are also other alternatives, which I think is on the next slide, but credit cards, you can do it as long as it's in the name of the trust and the funds or the charges on the card aren't for like food. So no fast food. So when we're talking about distributions, the beneficiary may want a television. You can buy the television for the beneficiary, but you can't give the beneficiary money to buy the television. So That's a specific example we found actually with one client. The trustee wanted to distribute out, $500 so that the beneficiary could go buy a television. You can't do that. That's why the credit card works really well. If you can get a credit card titled in the name of the special needs or supplemental needs trust, then you can charge Best Buy, wherever at Walmart, wherever it is that you're getting the TV. You can lease a vehicle. You cannot issue a check to the beneficiary outright. So, for example, in the Green family where we had John Green and he had siblings, you can't pay the check payable to John. So that's what that means. You can't issue the check to the beneficiary directly. You also don't want to issue it to the sibling either. So if the trust is designed for John's benefit, you can't make a distribution out for the sibling. The sibling isn't a beneficiary of the trust. So you can't issue a check directly to the beneficiary and you can't do it to the sibling. You don't want to distribute cash directly to the beneficiary or reimburse the beneficiary for any purchases. So with a supplemental needs trust, credit card is a great way to go. And then any distribution from the trust should be paid directly to the provider of the good and services. So again, when in doubt, if there is an invoice or something that needs to be paid, just pay directly to the company so that way it's not going out to the beneficiary, it's not being reimbursed, all of those things. The one thing that we did find when we were researching credit cards is there is something called a TrueLink debit card, and it's a trustee managed prepaid card. You cannot use the card to obtain cash. So it's not like an ATM card. And here the disabled person has a credit card and asks the special needs trust to pay the credit card bill. So the trust has no obligation to pay that. So that's why you want to get the credit card either titled in the name of the trust or you want to get one of these TrueLink debit cards, because if the beneficiary has a card in their name that's problematic, you can't just ask to be reimbursed, all that good stuff. So always, always, always get the card titled in the name of the trust. Okay, and the last thing I want to go over is the development of summary of our wishes. So in a couple of these, we had underage beneficiaries and we needed to do a summary of our wishes. So the summary of wishes is just communicating plans, maybe medications, doctors, certain routines that might help calm or settle the individual that you're dealing with. You want to make sure you're documenting that in the summary of our wishes so that future caregivers have a place to go for that. So this isn't actually a legal document. We do have a packet that we send out to our clients so that they can fill it out on behalf of their family for that beneficiary who might have supplemental needs. You want to make sure that you understand the eligibility for public benefits or talk to an attorney or an advisor who does understand that, and then plan to utilize public and private resources. So there are a lot of great government benefits out there that you need to make sure that you're familiar with, that you know. When in doubt, ask, because either a legal professional can get you the answers or they can connect you with somebody who can. October, we're doing from 12 to 1 p.m. I love my kids, but ... parental control after death. So we've done a lot of seminars about planning, but this one is going to be more similar to this, where we actually give hypotheticals and walk you through the different planning strategies that we used in that situation. So if you want to register, you can reach out to our website, fill out the registration form. You can call or text us at the number and we can register you, or you can always email Amy at her email and she can register for you as well. All right, so that concludes the presentation. Thank you all for being here. I'm sorry for stepping away unexpectedly because of computer malfunctions. So we are going to, like I said, post this on our YouTube link and have access to it through our website. So thank you all so much for joining us. I'm going to stop the recording now and we'll take questions. But thank you so much. This is Samantha from the law offices of Samantha Wolfe, and this was our monthly virtual seminar dealing with special needs trusts and how to plan for those loved ones in our lives. Thank you.